Well, good evening, everyone, and welcome to AJ103 Criminal Evidence Online. My name is Tony Farrar, and I am your instructor for this semester. Now, before we jump into Chapter 1, Introduction to Evidence, I wanted to bring up a couple of things. First, at the beginning of each chapter, there will be a case study that I'm going to cover just briefly. And I may even ask a couple of questions regarding some of the issues in the case study, but of course you're not going to be able to answer them right then. It's more just food for thought for you to think about as you read that case study further and add a little bit more context to the conversation. Now, I'm going to do my best to keep the lecture to approximately 45 to 60 minutes. And also, one other thing of note, there are some good student resources in the textbook, as the beginning of each chapter has a series of key terms, and at the end of each chapter has a series of discussion questions, which are a great way for you to not only add a little more context to the lecture, but to also help you study for your weekly quizzes and your chapter exams. And then finally, because these chapters are, again, the lecture's only going to be about 45 minutes. It's going to be difficult to cover every single topic, or more specifically, every single example that's listed in the book. Therefore, it really is incumbent upon you to go back through the chapter and read the chapter to not only add context, but to also look at some of the examples that are listed in the chapter that will help you understand the concepts quite a bit better. So with that being said, let's jump right into our featured case. In 2008, child molestation charges surfaced against Jerry Sandusky, a Penn State assistant football coach, and numerous victims came forward, but there were some inconsistencies in what they said in their testimony. And in November of 2011, he was arrested and charged with 40 counts of sexually abusing 8 boys over a 15-year period. And this trial started on June 11th, 2012. A jury of 7 women and 5 men were impaneled for this trial. And 8 witnesses, 8 men testified, providing graphic testimony about repeated sexual assaults. The jury itself was sequestered, and we'll learn what that means in a little bit, during the deliberations. And subsequently, Mr. Sandusky was convicted on 45 of 48 counts. He was sentenced to 30 to 60 years in prison, and he will be 98 years old when he is eligible for release. Now, as with a lot of the lectures that I'll be doing this semester, I do include links to news broadcasts and other videos that you can look at that help you add context. And in this case, this is a video that I believe is a news broadcast on the verdict reading in the Sandusky case, and you can watch that to get a little bit more detail. And then ask yourself this question maybe after you watch the video. Well, what procedures and what evidence were used? Ask yourself about evidence and what is it? And if you think you know what it is, then what kind did they use? Did they use it in the trial, and perhaps the most? So kind of, look at those questions. And along with Sandusky, other coaches, assistants, and the university were impacted by this case as well. So could the evidence be used for criminal charges against somebody else, or just Sandusky? And is failing to report a crime a crime? And how do you punish Penn State, the institution? So just some questions that you kind of want to think about as you're looking at the case study. So some of the learning objectives, and briefly I'm going to touch on them. And the reason I'm going to do that is because these are things that we want to at least come out of with a better knowledge of. So define what is and what's not evidence. Explain who has this thing called burden of proof. describe the roles of prosecutors, defense attorneys, judges, juries. What do they do? And specify the historical changes that have occurred in the way evidence is presented at trial. So what do we do now that we either did do back then or we didn't do back then? Identify 3 sources of law governing evidence and discuss the relationship between federal and state rules of evidence. Are they the same or are they different? And then how would we look up a case if we were given the legal citation, and what materials are used for legal research? So we're gonna try to answer some of those questions as we go through. So evidence, what is it? Well, we all use it. We use it every day. For example, we might look out the window and see what the weather is like and use this to decide what to wear. And retailers collect sales statistics and use the evidence to guide their marketing strategy. And teachers give tests to see how much their students are learning and use this evidence to perhaps assign grades or maybe change the way they do things in the classroom. And scientists, they conduct experiments and use the evidence to find cure for diseases. Now, police investigators, they're no different. They also try to gather as much evidence as possible. And if they are convinced a case has been established, then they're going to take all of this information, this evidence, all of this stuff to the prosecutor, and the prosecutor will evaluate the evidence. They're going to look at that evidence in that case in order to decide whether or not this case should go to trial or be filed. And the prosecutor again is going to decide to file the case, and then ultimately a judge or a jury will hear all of that evidence and decide whether or not somebody's guilty, whether that defendant is actually guilty. So I think you can see already, and we haven't even got a minute or two into the lecture, what the importance of evidence is. And along with that, there are many definitions of evidence, and a couple we'll look at really quick. So one definition is some fact that tends to prove or disprove the existence of an alleged fact. And another one could be the collective mass of things, especially testimony and exhibits. So people talking, witnesses, testimony, and exhibits, those tangible things that are brought in, presented before the tribunal or court in a given dispute. And that definition is from Black's Law Dictionary. So evidence in the legal sense includes only what is formally introduced at trial. Those things that are, those objects, those things that we're talking about, even testimony that is introduced formally at trial. And lawyers and judges use the phrase, and you'll hear them say that, introduced into evidence. And some commonly used terms such as inadmissible evidence is a bit misleading. Now, one side may attempt to admit something into evidence, but if it is not admitted, it doesn't become evidence in the case. Does that make sense? So one side may try to admit something into evidence, but if it's not admitted, it doesn't become evidence in that case at all. It doesn't get in, if that makes sense to everybody, and I think it should. And a wide variety or a wide range of things can be used as evidence, and we talked about those, testimony and exhibits, those tangible things, but let's kind of go into a little bit more detail. So if you go to court and watch a trial, the most obvious evidence is the testimony of witnesses. What a person says from the witness stand while under oath is in fact evidence. And also like physical objects such as a gun, and there's so many other physical objects, but we're just going to use this as an example, may be introduced into evidence, but only after a witness has testified about it, thus providing a foundation for its admission. And we'll talk more about that in a little bit. And such testimony might include the circumstances under which the gun was found. So the variety of things that can be used as evidence is only limited by the facts of the case. Meaning a gun might be evidence in a murder case where the victim was shot, but not in a murder case where poison was used to by an unarmed assailant. So hopefully that makes a little bit of sense too. And along with the many types of evidence, documents can also be evidence. And anything written or printed, pictures, still movies, videos, sound recordings, electronic files are all considered documents when introduced into evidence. And a forged check is a document, and so is the demand note given to a bank teller during a robbery. And counterfeit money would also be considered documents, as would graffiti on a wall or inscriptions on a tombstone. Emails and text messages are also documents. And court records can be real important documents if the prosecutor needs to prove that the defendant has a prior conviction. And there's some evidence that is actually developed just for trial. So a wide variety of tests are done in forensic laboratories to prepare cases for trial. The defendant may be fingerprinted solely for the purpose of comparing his or her prints found at the scene, or a DNA sample may be taken for comparison purposes. The case may be reenacted to determine if the scenario described by the witness could be true, and scale models and digital animation may even be developed for submission as evidence. So several chapters in this book are going to be devoted to explaining what evidence is legally admissible in court. And again, remember, the mere fact that something could be admitted is not enough. There's this procedure where the proper groundwork has to be laid before the judge will allow evidence to be introduced. And we'll cover some of these requirements as well. So hopefully that kind of clears up a little bit regarding, evidence. And since the Supreme Court decided this case called Mapp versus Ohio in 1961, the police have also had to be concerned with how evidence is obtained. So we know a little bit about what it is, and this Supreme Court landmark decision case, Mapp versus Ohio, brought forth the issues concerning illegally obtained evidence. So law enforcement, we have to be concerned with how we obtain it, because if we don't obtain it properly, we're going to have some issues as to its admissibility. So when you talk about legally obtained, to be admissible, evidence must have been legally obtained. And this Mapp versus Ohio case is a big one. And just to briefly talk about it, police looking for a suspect forced their way into the house of Dalree Mapp without a warrant. In fact, they showed a fake warrant to her, which they forcibly took from her when she grabbed it from them. And during the search, police didn't find the person, that suspect they were looking for, but they did stumble across some pornographic material, which in this particular state was illegal at that time. And so Mapp was arrested and convicted for possession of pornography that had nothing to do with the original case. Now, this went all the way up to the Supreme Court, which overturned her conviction and basically barred the admission of such evidence. And the rule that came out of this was evidence that was illegally obtained is inadmissible. And a lot of times when we talk about these cases, as you can see here, I'll have a link at the bottom that you can go to, which will take you to a case summary. And maybe I'll do just one so you can see what it looks like if it works. Okay, so it's not centered, but it'll take you to a case summary, which is kind of cool. And again, so it's Mapp versus Ohio, and if I move the screen over, you can see the whole thing, but I'm going to kind of move it back. It talks about the facts, it asks the question, it gives the conclusion, but one thing cool, it tells you the decision, the vote, and then gives you the rationale why this particular Supreme Court said what they said or voted how they voted. So, excuse me. So hopefully that really makes it easy for you to kind of understand this particular case. And I apologize, I'm having a problem getting back to the slide. And let me see if I can get back. I don't know. I may have actually knocked myself out of the whole thing. Oh, I didn't. Okay, good. Great. So, again, evidence illegally obtained is, in fact, inadmissible. Now, along with this illegally obtained evidence comes this thing called the exclusionary rule. And that's what came out of this Mapp case. And we'll talk more about it. We'll define it more later. But the question that we ask ourselves about the exclusionary rule, meaning that evidence illegally obtained will be excluded from trial. We're going to ask this question. If a fact or evidence exists, is it fair or rational to ignore it in determining the truth? So if we know that there's a fact or some evidence that exists, is it rational for us to basically ignore it in determining the truth? Well, the Mapp versus Ohio case keeps out evidence that is true in order to balance or protect our constitutional rights. So is this really the best application of the right? Meaning excluding evidence that may have been obtained illegally? Or is it okay, the end justify the means, if you will? So even if you obtain it illegally, should we just go ahead and use it in court? Or is it, I guess, more fair, if that's a good way of putting it, to make sure that law enforcement knows the rules in which they are to work under, and as long as they know those rules, if they violate those rules, then again, by seizing evidence illegally, then that item of evidence, and of course anything discovered after that as a result of that item of evidence, could be excluded at trial. So a lot of questions, and you can look up the exclusionary rule, but we'll talk a little bit more about it later. So now we're going to talk about, now that we've sort of covered just basic evidence, we're going to talk about, as we make the arrest and we use evidence at trial, what does the burden of proof provide, and how does that come into play, and what does it really even mean? Well, it is widely said that the prosecution has the burden of proof in criminal cases, and this means that the prosecution is required to produce credible evidence to prove every element of each crime charged. So the proof must be what? What kind of proof? Well, there's different levels, if you will, and this chart or this graphic shows you some different levels of proof, and we're not going to walk through all these right now because we're concerned with the one that's at the top. And the proof in this particular case that we're talking about must be beyond a reasonable doubt. So the prosecution is required to produce credible evidence to prove every element of the crime charged. And in order to convict, this proof must be proven beyond a reasonable doubt. Now, this does place a heavy burden on the prosecution. And the American society, however, has decided that it is better to let the guilty go free than to convict innocent people. Thus the reason the burden is so high. And really, I think, in all fairness, it should be high. So again, at criminal trial, the prosecution must meet this standard, this beyond this reasonable doubt. And the prosecution has to convince the trier of fact, which you'll find out who that is in a minute, that the defendant is guilty. And they have to look at the definition of each crime and make sure that proof has been presented on each element of every offense. And even that beyond a reasonable doubt burden there is listed in what we call jury instructions. So when a case is completed, before it goes to the jury to decide the fate of the individual, a set of jury instructions might be issued, and the definition of beyond a reasonable doubt would be used or can be used by some courts. And in your textbook, we're not going to have time to go through it. On page 5, about the middle of the page, it talks about a jury instruction used by some federal courts, gives a useful explanation, and it talks about it right below that. So as we move on, and we're still talking about this beyond a reasonable doubt, the prosecutor, again, is required to fully satisfy the jury that the defendant committed each crime charged. Now, the defense does not have to prove that the defendant did not commit the crime or suggest who the culprit was. But in a practical matter, the defendant is more likely to be convicted if no defense evidence is presented. And it is usually safer to cross-examine prosecution witnesses and call defense witnesses in order to convince the jury that the prosecution's evidence does not establish the case beyond a reasonable doubt. So another way to explain this adversarial relationship between the defense and prosecution is that the prosecution has the burden of producing evidence that establishes the crimes beyond a reasonable doubt. The defense, on the other hand, has what we call the burden of persuasion. And this means that the defense must persuade the jury that the prosecution has not established the defendant's guilt. And again, the standard doesn't mean proof beyond any doubt, okay? It's beyond a reasonable doubt. Now, there are some special situations in which the defendant does have the burden of proof. Okay, and these are so-called, or what we call, affirmative defenses. And these would include a set of facts other than those alleged by the prosecution that is proven that provide a defense. And these could be things like self-defense and duress or intoxication or entrapment or insanity. These are good examples of what we call these so-called affirmative defense. So in order for the defense to use these, the defense must introduce evidence on these issues. And some states even require the defendant to prove them, usually beyond what they call a preponderance of evidence. And I don't know if I had it on the chart, but if you go back, you can see preponderance right here, more than likely or not. So different levels of these burdens of proof depending upon what it is that we're actually talking about. So that's just briefly kind of going over this the trial and what level is needed in order for the prosecution to convict. Well, let's look at the roles of these people, the judge and the jury. So in a jury trial, the roles of the judge and jury they're distinct. The judge is the trier of law, and the jury is the trier of facts. If the case is heard without a jury, the judge will play both or do both. So the trier of law, okay, that's the judge, determines what laws apply to the case. So the judge always determines what the law is on any given point. And hopefully that kind of makes sense. This is clearly shown in the selection of jury instructions. And not as obvious, but equally important, is the role of the judge in deciding what evidence is admissible at trial. This is easier in some areas than others. So the judge is the trier of law and always determines what the law is on a given point. And if there's no jury, the judge also determines the fact as well. The jury is the trier of fact. And they determine if evidence is in fact to be believed. And they determine actually what weight to give to testimony, documents, or physical evidence. The jury is going to be, those are the ones that are going to put the weight on that. So you can see the importance of proper jury selection as well, and the role that the jury plays in the criminal justice system. So as it relates to admissibility, the judge controls what evidence will be admitted. So again, we'll go back. The jury determines what weight that's given to that testimony, that evidence, whether it's documents or physical evidence or testimony. But the judge, they control what evidence will actually be admitted. And a presumption does exist that evidence is admitted unless, of course, it's objected to by the defense. So there is a presumption built in there, but for the main point here is that the judge controls what is to be admitted. And perhaps the most difficult decisions are those where the judge has to rule on specific questions the attorneys want to ask witnesses. And although some questions are obviously permitted and others are not, there's kind of a gray area in between. And the judge must apply the law to these situations, and they have to make a ruling on it. They can't just be quiet. They have to decide, hey, which side am I going to rule for here? And the judge must apply the law to these situations and use what they call judicial discretion. So this applying the law to these situations and making this ruling, all of this is referred to as judicial discretion. And the judge has the legal right to decide if, in fact, questions should be allowed or not. So kind of review this judicial discretion. Judge has the legal right to decide if the questions the attorneys ask should be allowed. The judge determines the competency and even relevancy of materiality of the evidence. And the judge also looks at how prejudicial evidence might be. And we'll talk a little bit about prejudicial evidence in a minute. So, continuing with judicial discretion, a good example of this use of discretion is the right to ask questions to test the witness's memory. And the Sixth Amendment gives criminal defendants the right to cross-examine their accusers. Now, obviously, this includes the right to try to show the jury that the witness has a bad memory, and typically that they will do this. On the other hand, it's unrealistic to expect a witness to recall every minute detail of an event that might have happened a year ago. So this is very difficult, and this is part of this judicial discretion thing that we're talking about, where the judge has the discretion on what questions, etc. And additionally, excessive questioning wastes time and may confuse the jury, and at some point the judge will rule that no more questions are going to be allowed. And then sometimes evidence that's just too prejudicial, like extremely graphic photographs of a murder victim, those might be inadmissible. And while the jury needs to know the facts of a case, there is the danger that exposure to certain photographs will cause the jury to focus on the horrific nature of the crime rather than the proof of the defendant who committed it. Does that, and I think that kind of makes sense to everybody. So in 2000, the United States Supreme Court decided the case of Apprendi versus New Jersey. And this case interpreted the Sixth Amendment right to a jury trial as mandating that a judge use facts in sentencing only if the jury had determined beyond a reasonable doubt that the facts were true. And this applies to allegations, sometimes enhancements, that would result in longer sentences, such as the use of a firearm during a crime or inflicting serious bodily injury on a victim. So in this particular case, and again, we'll just brush over it, you can click on the link for more, the Supreme Court limited judges' power to include any fact in sentencing, and that only those facts shown beyond a reasonable doubt may be used to determine a maximum sentence. And the judge used information in this case not conclusively proved to basically expand or enhance this person's sentence. And as you read more about the case, you'll get it, but Apprendi in this case may have committed the crime because of racial bias, but if not shown beyond a reasonable doubt, the judge, they're saying in this case, shouldn't be allowed to use it to enhance the sentence. So all of the facts need to be beyond a reasonable doubt. So click on that link and get a little bit more information. Well, what about the prosecutor now? Well, the prosecutor is one of the gatekeepers of the court system, and the grand jury is another. And in most U.S. jurisdictions, all criminal charges must go through one of these two portals, if you will. And some states require felonies to be reviewed by both. Infractions such as traffic tickets can frequently be filed with the court without their screening. And the United States Attorney, well, let me back up. The prosecutor is also typically the one who initiates criminal proceedings. They're the ones that are going to file the cases and initiate that entire criminal proceedings. Now, the United States Attorney is the prosecutor in the federal system. The U.S. Attorney for each U.S. District Court is appointed by the President and confirmed by the Senate, and subordinates are hired using kind of a civil service system. And the most common organizational structure in the state court is a county-level prosecutor, usually called, the word that you've probably heard, the district attorney or the state's attorney. And the prosecutor's office is usually divided into at least three functions, and that's like filing charges and trials and appeals. So the state prosecutors, again, are called district attorneys or DAs. The prosecution does represent the state or government at trial, and the prosecution also handles appeals and verdicts. And again, they divide these offices are typically divided into three functions: filings, or filing charges, trials, and appeals. So in many jurisdictions, the prosecutor is readily available to assist law enforcement before an arrest is made, reviewing affidavits needed to obtain search warrants, which would be one thing that they might do. So do legal opinions on specific practices, as whether a sting operation involves entrapment or things like that. And some prosecutors provide training bulletins and seminars on how to train local police officers. And an alternate approach is for the policing agency perhaps to even employ its own legal advisor. So conceptually, the prosecutor is on the same side as law enforcement. Now, the role of the prosecutor is pretty complex. And on one hand, he or she represents the government and is charged with convicting those who are guilty. And on the other hand, prosecutors must seek fundamental fairness. And these duties have been clarified by a number of U.S. Supreme Court decisions, as well as the American Bar Association's Model Rules of Professional Conduct and the National District Attorneys Association and law organizations and in each state. So before trial, okay, there's a phrase out there called prosecutorial ethics. And this is where we seek arrest and search warrants only with probable cause. And we have to disclose all useful evidence to the defense. And we are to prevent undue publicity. And again, ensure constitutional safeguards are followed. So these are all what we call prosecutorial ethics. And we've already talked about the fact that the prosecution does, in fact, assist the police. Now, the Sixth Amendment right to counsel attaches at the first court hearing in a case. And the prosecutor is ethically bound to make sure that the defendant is advised of his or her right to counsel and to refrain from contacting that defendant directly. And the Supreme Court held that due process demands that prosecutors, like I said a minute ago, disclose all what we call exculpatory evidence to the defense in a timely manner. And while the case law has focused on pretrial disclosure, the ethical duty extends to information obtained both before and after conviction. So these are just some prosecutorial ethic things that have to be done, and we've talked a little bit about what the prosecutor's kind of role is. And as we go a little bit further and we talk about arrest to trial, well, preparation comes into play. So for minor cases like traffic tickets, they really don't do that, but they generally only read police reports. And on major cases, there's the need to interview witnesses and review evidence and determine the likelihood of conviction and look at the level and the number and types of charges and then determine if a plea bargain might actually be appropriate. And all of these are the prosecution's role, if you will. Well, what about the defense? The role of the defense attorney? Well, the Sixth Amendment gives the defendant the right to have assistance of counsel for his or her defense. And denial of this right is automatic grounds for reversing a conviction and ordering a new trial, no matter how strong the evidence of guilt was in that first trial. Now, the Supreme Court also ruled that a conviction should be reversed based on the incompetence of an attorney if the inadequacy of that attorney affected the outcome of a case. And we'll look at that case, I believe, in just a minute. But the Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against them, to have compulsory process for obtaining witnesses in their favor, and to have the assistance of counsel for their defense. And here's a link to a video if you want to know a little bit more on the Sixth Amendment. So again, we talked about that Supreme Court case, and let me go up here. Okay, so it is here. So the defense carries with it what we call the burden of persuasion. And here the defense has to show that the prosecution has failed to prove guilt beyond a reasonable doubt. And they can, as we've already heard, raise affirmative defenses like self-defense and duress and intoxication, entrapment, and insanity. And they can attack the constitutionality of how evidence was obtained. And typically, that's where a lot of cases come into play, at least on the defense side. And we know that the defense attorney, we have the right to counsel, and it's guaranteed under the Sixth Amendment. And if denied, any conviction will be reversed. And I just told you defense attorneys have to be reasonably competent. And if you cannot afford one, the state, of course, will in fact pay for one. Well, here's the case that I wanted to get to. In Gideon versus Wainwright, the court held that the right to counsel is so important that an attorney must be provided at no charge for a defendant who can't not afford one. So overlaying the Sixth Amendment right to counsel is the due process right to a fair trial and to have guilt established beyond a reasonable doubt. And a plea of not guilty merely sets the stage for these constitutional rights. And defense motions to suppress evidence found during searches or confessions activate the defendant's Fourth and Fifth Amendment rights. And we already know what the Sixth Amendment kind of encompasses. So in this case, Gideon was charged and convicted of stealing from a coin-operated cigarette machine. And at trial, he asked for counsel, but he was denied counsel. And counsel was only given to those that were facing a capital case. So he was convicted and sentenced to prison. Well, he handwrote his own request for a new trial, and on appeal, the Supreme Court mandated counsel, this was the outcome, for all indigent, or those that might be more or less fortunate, poor defendants who face any active prison time. And you can click on the link and it'll take you there. And this is based on the Sixth Amendment. So again, we've got these precedent cases that are so important. So we talked a little bit about applying the law on public defenders. Well, a couple of questions. Well, how good is good enough? And private defense counsels may handle a dozen serious cases at a time, but a public defender may have like 60 or 100 felony cases. Now, recently, some states have cut back severely on funding for public defenders. But one thing of note, okay, and this could be a good thing or not a good thing, it depends on how you view it. Almost all trials end in what we call a plea or a plea bargain. About 95 to 96%. But is this just? Is it just that 95 or 96% of all trials end in an agreement, a plea bargain between the prosecution and the defense versus an actual trial? But imagine if all cases went to trial. Would we have enough time in the weeks and the months and the years and the decades to try all of those cases if they went to trial? So there is a reason for plea bargaining, and we'll talk more about that later. So the defense attorney's duty, to kind of end up the role here of the defense attorney: ensure due process of law, protect defendants from illegal searches and confessions, and cross-examine hostile witnesses, and ethically not engage in or promote fraud, or not file or seek frivolous claims, or not present false evidence to the court. These are in fact part of the duties. Well, a little bit of history, and then we'll start to kind of wind down a little bit. Historically, trials were often unfair. And, you know, the rules of evidence were designed to control both the judge and the jury. They were also intended to make the trial more businesslike and efficient. And the evolutionary process that resulted in the present rules of evidence in the United States is a reflection of both English and U.S. history. And when you start to look at a lot of how this happened, like in the Middle Ages, glaring abuses of the trial process, like the Star Chamber and the Inquisition, were developed. And strangely enough, the Star Chamber was originally developed to cure abuses by the royalty. At their height, both the Star Chamber and the Inquisition became obsessed with obtaining confessions. And the noble ideal that a person could not be convicted solely on the allegations of others dissolved into a nightmare of torture chambers, basically designed to force people to confess. So it kind of, the Star Chamber and Inquisition kind of started with a presumption of guilt. And at one time, jurors were selected based on their knowledge of the case, how much they actually knew. Unlike the present American system, in which jurors are not supposed to have an opinion about a case prior to the trial. Early jurors were only selected if they had personal knowledge of the facts. So busybodies, if you will, made fabulous jurors. And jurors were also given the right to conduct their own little investigations into cases. And few rules existed to keep bad evidence out. So you can see how this is really kind of not good. And during the 16th century, the rule was developed that anyone having a personal interest in a case was disqualified from testifying. So we're seeing some reform. And this was based on the belief that someone with an interest in a case would be more likely to be biased and untruthful. And in addition to disqualifying people with a financial interest in the outcome of a lawsuit, this rule prevented parties to the case from testifying. And as with many reforms, the rules that emerged were found to be too rigid. Exceptions to the rules were developed to make the new rules work better. And the numerous exceptions to the hearsay rule are good examples of this problem. Or, I'm sorry, of this particular process. So we talked a little bit about the 16th century. The rule developed that anyone having a personal interest in a case was disqualified. And the spouses of parties in these particular cases were also disqualified as witnesses. So with this being said, and we see some of these reforms that have kind of come about, if you will, and just to finish up maybe on the reforms, from time to time, legal reformers have attempted to replace the old rules with more modern ones, and some prestigious national organizations like the American Law Institute and the National Conference of Commissioners on Uniform State Laws have solicited input from leading scholars in the field and drafted model laws which they encourage legislators to enact. Now, unfortunately, the U.S. federal system of government makes system-wide reform pretty much impossible. And except where the U.S. Constitution is controlling, each state is free to enact its own rules of evidence. So somewhere in the legislative process, the model codes are frequently altered or amended. Therefore, an evidence, as in many areas of the law, each state or each state's law on evidence is a bit unique, if you will. So where do we get the sources? So we've talked a little bit about evidence, and we talked about burden and some of the players in this system dealing with evidence, but what about sources of law or evidence law? Well, evidence law reflects both history and the strengths and weaknesses of the U.S. federal system of government. And both statutory law and case law have definite impacts. Federal and state laws basically intersect. And as you learned in high school, the U.S. Constitution is the supreme law of the land, but there is very little in the Constitution that has a direct bearing on evidence. Now, several provisions in the Bill of Rights, however, control actions of government in criminal prosecutions. And although early Supreme Court decisions found no connection between these protections and the admission of evidence, during the mid-20th century, the court began considering whether the Due Process Clause of the 14th Amendment made the provisions of the Bill of Rights applicable to the states. So, the United States Supreme Court, and as we kind of talked about a minute ago, evidence is only one of these many topics addressed each year in the opinions of the U.S. Supreme Court. And two important functions of the Supreme Court should be noted here. The first is the court is the final arbiter of the meaning of the U.S. Constitution. And second, the court acts as supervisor, if you will, of the federal court system. Decisions of the court that interpret the Constitution are binding on all federal and state courts. And when ruling on the meaning of the Constitution, the Supreme Court has the authority to overrule any court in the nation. It also has the power to overrule its own prior decisions. And gradual changes can be seen in the court's decisions as justices, of course, retire and are replaced. So the U.S. Constitution, so sources of evidence law, the U.S. Constitution, particularly the Bill of Rights, as interpreted by the courts. And the U.S. Supreme Court defines what the Constitution means, kind of like what I just said. And it supervises the federal court system. Well, what about this last part? Federal Rules of Evidence, this FRE. Well, the federal rules of evidence govern the admission of evidence in federal courts. And this comprehensive set of rules was adopted by the U.S. Supreme Court and forwarded to Congress, where they were duly enacted. And some of the rules have been amended since they first went into effect back in 1975. And enactment of the federal rules of evidence was significant for a lot of different reasons. They were a comprehensive set of rules designed to work together as a whole. And the authors believed they incorporated the best of the old law and corrected the problems that had developed. The new rules replaced both the existing statutory and case laws. So this is a pattern that is and has been adopted by many states. So you have the Constitution, you have the Supreme Court, and you have federal rules of evidence. So what about state rules of evidence or state Supreme Courts? Well, each state has the right to enact its own evidence code. And while many states now follow the federal rules of evidence, some states, like Arizona and California, have enacted their own comprehensive evidence codes. Determining the evidence law in states that follow either of these approaches is, in fact, fairly easy. So you have state Supreme Courts and their interpretation of their own state's constitution. And then we have what we just discussed, the state's rules of evidence. While many follow the FRE or the federal rules of evidence, others, California being one of them, have kind of adopted their own unique set of rules. And then finally, there's case law. The U.S. legal system is based on the concept that the legislature enacts laws, but the courts interpret them. And as a result, it is necessary to stay abreast of the actions of the legislature, which create new laws and amend existing ones, and the decisions of the courts that clarify their meaning. And these decisions are referred to as case law, and we'll talk a little bit more about that in Chapter 2. Now, one problem that arises in using case law is that there is no automatic feedback from the courts to the legislature. And even though the U.S. Supreme Court or the highest court in the state has ruled that a code section is unconstitutional, there is no way to change the code except for legislator to pass a law that amends or revokes it. So for this reason, there's kind of a delay in revising the codes. And sometimes the legislature doesn't follow through with the process, and the codes retain kind of invalid areas or even invalid sections. So how do we research case laws and find stuff? Well, legal research requires access to a variety of materials, and the process usually starts by determining the law that is applicable. And your textbook could actually be a good starting point, but good research requires more depth, if you will. So without reading every single thing inside here, we can look at the rules of evidence and know that they evolve with society and technology. And here's a couple of cases that you can look at that'll start to show the evolution of law. And again, we're going to talk about that research on how to look up a case in a minute, but take a moment and look at these cases that are relative to the evolution of law. And you have Katz versus U.S., which is a really cool case. Now, even though it's older, 1967, it talks about the Supreme Court that developed rules about expectations of privacy under a really cool circumstance. And then U.S. versus Jones, that is where the court first applied rules on GPS, on trackers. So look at these two and have a better understanding on how the rules of evidence evolve with society and now with technology. And then finally, legal research. Well, to do this, we can look at, comprehensive legal sources like encyclopedias. I put Wikipedia in here, but it's not always the best. There could be things like American jurisprudence or Corpus Juris Secundum. You can look in legal newspapers or legal digests or annotated codes. and you'll be able to kind of get a better understanding on how to find cases. When you look for court opinions, they're found in different locations, public and private. And here what I've done is kind of make an example of these. So when you look at the case, I've color coded it so they somewhat match. So if you look, this is the case of Miranda versus Arizona, and it's linear right here, okay? And so Miranda v. Arizona, 384 U.S. 436 1966. Well, oh my gosh, what is this junk right here? Well, for here we can match these up color code. Miranda was the appellant who lost the case at trial, and verse Arizona was the appealee. Okay, the folks that convicted Miranda, the state of Arizona, or the Arizona courts at that particular time. And the case can be found in volume 384. So this tells you, so the first number is the volume. U.S., which is the United States Supreme Court reports. 436, starting on page 436. And that's an example of a case citation. Okay, so again, we made it just about a minute late, but that's okay. We went over by a minute. Again, if you have any questions, you can post them on the general discussion board, and I would be happy to answer them, or another student can kind of chime in and answer them. Or if you don't want to post it there, you can email me, and I'd be happy to answer it, because more than likely your question, somebody else has the same question. Keep in mind the student resources in the textbook, the key terms that are at the beginning, and also the discussion questions that are at the end of each chapter. Take the time to go through those. An example for like review questions would be like, define the general term evidence. Well, we talked about that at the very beginning, so these are things that you can do to kind of study for your weekly quizzes and also your chapter exams. Those case laws that are in the PowerPoints, feel free to click on those and look at them and read them a little bit more, and also the case studies as well. But with that being said, that's going to conclude our lecture for Chapter 1, and